Hi, my name is Josh Blackman. I am the founder of the Harlan Institute, and today I'm proud to present the first match in Harlan Institute ConSource Virtual Supreme Court competition. I am very proud to sponsor this competition with my good friend Julie Silverbrook at ConSource, and we have two fantastic teams today. Julie, would you like to say anything?
I just want to wish both of the teams the very best of luck. We are looking forward to this first round of oral argument.
Thank you so much, Julie. Today's case is Timms versus Indiana, which presents the question of whether the Eighth Amendment's prohibition on excessive fines is incorporated. We've mixed up the competition a little bit to make it a little bit more fun. The petitioners will have to argue that the Eighth Amendment's prohibition on excessive fines is a privilege or immunity of citizenship. And the respondents will argue that the due process clause of the 14th Amendment is the proper path for incorporation. Now, we know the Supreme Court decided this case, but we will pretend they haven't yet, and we'll argue under the veil of ignorance, so to speak, and we'll see how our teams perform. The first team are the petitioners from Lighthouse. They are going to be speaking for 15 minutes, and we have Curtis Herbert and Sana Wazwaz. And the respondents will be Elena Lee and Sydney Von Arx from Lake Oswego, Oregon. Each team will have 15 minutes for openings and 5 minutes for rebuttal. Okay? Minnesota, you guys ready?
Yes.
Okay. We begin whenever you're ready.
Your Honor, may it please the court. The right against excessive fines is deeply rooted in history and tradition, and the states must not infringe it. But the proper mechanism for incorporation is the Privileges or Immunities Clause. When the 14th Amendment was being debated in Congress, its Senate and House sponsors explained precisely what privileges or immunities were protected. Senator Howard, quoting Bushrod Washington, who was riding circuit in the case of Corfield versus Coryell, tells us they are, quote, are in their nature fundamental, which belong of right to citizens of all free governments, end quote. They include protection by the government, the enjoyment of life and liberty, with the right to acquire and possess property of every kind, and to pursue and obtain happiness and safety, subject, nevertheless, to such restraints as the government may justly prescribe for the general good of the whole. Howard then tells us that, to these privileges and immunities, whatever they may be, for they are not and cannot be fully defined in their entire extent and precise nature, to these should be added the personal rights guaranteed and secured by the first 8 amendments of the Constitution. John Bingham, who is the House sponsor for the 14th Amendment, spoke in a similar way about the clause, especially with regard to the first 8 amendments. And a torrent of bipartisan scholarly papers, law review articles, and research clearly demonstrates that this understanding of privileges or immunities that was held by Howard and by Bingham was widely accepted.
Counselor, may I ask you a question, please? Has this court ever had occasion to address the 14th Amendment's privileges or immunities clause before?
Absolutely, Your Honor. In the Slaughterhouse cases, just mere years after the passage of the 14th Amendment, the Supreme Court ruled that the privileges or immunities clause protects only a narrow set of national rights, in a 5-4 opinion by Justice Miller. This opinion is widely been denounced because it fundamentally misunderstands the history and the original public meaning of the amendment, and it is our position that Slaughterhouse should be overruled and that the privileges or immunities clause should be restored to its proper place. We propose that the court do this by implementing the Glucksberg test to determine what constitutes a privilege or immunity of citizens of the United States. And if I may, Your Honor, there are several distinct benefits to the Glucksberg test. Firstly, it limits rights protected by the 14th Amendment to those that are deeply rooted in history and tradition. This is much more limited and much more constrained than the court's modern due process clause jurisprudence, which recognizes all sorts of rights that cannot be said to be historically grounded. Another benefit of this test is that this one follows closely on the first benefit, which is that it adheres closely to the original meaning of the Constitution. So we propose.
So, Counselor, if I may interrupt just briefly, the Slaughterhouse case was decided in 1873, so it was 150 years ago. We often talk about stare decisis, the idea of precedent, right? That the court should stand by their precedents. Why do you think a case that's been around for 150 years we should now overrule when we don't need to? We can and use the due process clause, as your friends on the other side will probably argue. Why should we overrule Slaughterhouse now 150 years later?
Well, stare decisis is a very important value, Your Honor. But in Casey versus Planned Parenthood, the court adopts a test for when it is wise to overrule a case. And I'd just like to note that the most important factor of this test is the reliance interests. When the court talks about stare decisis and adherence to precedent, that is what it focuses on. And there are no reliance interests in this case. The petitioner, Timms, does not matter to him whether his right against excessive fines is protected by privileges or immunities or by due process. And the Slaughterhouse cases have certainly had a negative effect on our court jurisprudence because they forced the court to expand other clauses, namely the due process and equal protection clauses, beyond their original meaning to pick up the slack for the work that the privileges or immunities clause has been doing. And I'd also like to note that in cases such as Janus and Wayfair, decided last term, and many more, the court doesn't necessarily require a special justification for overturning a decision. Simply that a decision was, as Justice Alito says in Janus, poorly reasoned, or as the Slaughterhouse is widely being called, just a bad decision out of touch with the meaning of the 14th Amendment, simply because of the grievously erroneous nature of the case. That in and of itself is sufficient reason for overruling, especially given the lack of reliance interests and other important considerations. So to circle back, despite the years of dormancy that the Privileges or Immunities Clause has had, and we can trace this through Sains versus Roe and McDonald versus City of Chicago, the court should overrule Slaughterhouse and restore the Privileges or Immunities Clause to its proper place. Now,
Counselor, can I interrupt you? What is the impact of doing that? If we overturn Slaughterhouse and as you say, restore privileges and immunities to its proper place, what does that look like for us moving forward?
Well, firstly, what you're doing is adopting a very historical test rather than the somewhat historical, somewhat ahistorical test the court has adopted in many of its incorporation cases. Also, we're adopting...
Sorry, Counselor. So explain to me why that's better.
It's our position that a historical text is more in line with what the Constitution demands.
Why?
If you're looking for a pragmatic reason, I might suggest that the expansion of due process and equal protection has not been good for this court. Because of the rise of modern substantive due process doctrine, a lot of justices who view it as being ahistoric have been more hesitant to confront rights that we think are historically rooted. Take, for example, Justice Thomas's dissenting opinion in Sessions versus DiMaio. Justice Thomas says that if the vagueness doctrine is another example of the court's, what he perceives as overreach in the area of substantive due process, then there's all the more reason to doubt it. And we think that an approach that recognizes the proper history will not only be good in and of itself as more direct adherence to the Constitution, but will benefit the court by allowing the justices to think clearly about other rights and to rule in a consistent way in other cases.
So let me ask you, I think, one of the more challenging questions that I think you need to help us think through, which is, let's say we do what you ask. What happens to all of the previous cases under which we ruled through the substantive due process clause?
Well, those cases, for the large part, I think would be certainly upheld and ruled decided much the same way under privileges or immunities clause. As Bingham and Howard note, the rights from the First State Amendments, those rights which can be incorporated from the First State Amendments, are protected, and the court has incorporated many of those same rights, and we're not asking the court to suddenly relitigate, a dozen cases that would come out virtually the same way.
So are you saying that if we were to overturn Slaughterhouse, go with your privileges or immunities theory, we wouldn't have to touch any of the cases under which we've already done incorporation through substantive due process? Is that what you're advocating? Those
clauses would be incorporated, and I might add, the approach that, with respect to the sort of two-track rights, as State of Indiana calls it in their brief, the Supreme Court, when it recognizes a federal right that applies to the states, the Supreme Court holds that that right applies in the same way to the states as it does to the federal government. And we're not seeking to touch that either. So I think by and large, those cases would stand. The states would still be bound to protect those rights, but perhaps by a different clause in the Constitution.
But Counselor, so we don't just hear cases, right? There has to be a live dispute. We're not going to just, reconsider those cases. But if you're asking us to rule in a way that would essentially do away with the substantive due process route for incorporation, that would open an avenue for people to challenge all of those previous cases under the new privileges or immunities rather than substantive due process theory. Is that correct?
Perhaps, Your Honor, but the standard that we're using, this historical standard, is, while not precisely similar to what the court has used under due process, it's similar in many aspects in that it looks to history.
Okay. Flesh that out for me.
Yeah, and if I could build on Justice Silberberg's question, what sorts of rights would not be protected under the Glucksberg test that are protected under the substantive due process test? In other words, what there's a lot of overlap. I get it. I think you're right. There's overlap. But what would be out? What would actually change were we to go down the road you propose?
Well, and not just added, what would be lost?
Yeah, exactly.
Well, I think, Your Honor, when we're talking about cases that might have been decided differently under the Privileges or Immunities Clause, like perhaps a Bergefell versus Hodges or Casey versus Planned Parenthood, it is important to note the stare decisis concerns in those cases, whereas the stare decisis concerns in the slaughterhouse cases are less. The stare decisis concerns in those cases are more. And what we propose,
Counselor, you already mentioned this, but tell me why you have that distinction between the stare decisis being an issue in these more recent cases, but less of an issue in this case that's been around for over 150 years.
There are a lot of people that are relying on decisions like a Bergefell versus Hodges and like Casey versus Planned Parenthood when they make decisions in their personal lives. Those are the sorts of reliance interests that the court accepts. The court doesn't accept a reliance interest that says, well, we've been doing it for so long, so we may as well simply keep doing it. And when you look at cases like Casey and Bergefell, they accept those reliance interests. They also accept reliance interests in cases such as Wickard versus Filburn and Humphrey's Executor, which concern fundamental provisions of our Constitution that govern the interaction between various bodies of government and between the government and the states with federalism. But there are no federalism concerns with slaughterhouse, at least not because of the due process clause incorporation. And so in that way, I think the stare decisis concerns in those cases are very distinct.
Okay.
So maybe get you back on track to the actual case we have here. Why is the prohibition on excessive fines a privileged immunity? We started off by talking about Bingham and Howard, but let's link the specific right at issue here, the excessive fines clause. Why is that a privileged immunity of citizenship should be protected by the 14th Amendment?
Well, I think when you're looking at the privileges or immunities clause, it's also important to look at it in the context of what were considered rights at the time of the 14th Amendment's ratification. And the context in this area is very, very important. So when the 14th Amendment is being ratified, it's being ratified in large part to prevent the massive scale infringement of the rights of freed slaves that is going on in the post-war South. And these infringements of rights take all sorts of different forms, but I think it's important to note that some of these forms are excessive fines, and that the right against excessive fines traces its roots not only through the ratification of the 14th Amendment, not only through the ratification of the Constitution, but also all the way back to the Magna Carta, a ban on fines that deprive a person of their livelihood. And so in that respect, I think it is very, very, it's a high bar to say that excessive fines is not protected. And regarding the scope of this clause, there's a lot of discussion about whether in rem civil forfeitures qualify as excessive fines. But the Supreme Court has actually ruled on this. In Austin, this court held that if a forfeiture is partially punitive, then it constitutes a fine for purposes of the excessive fines clause. Now, Austin was a case concerning the federal government, but as I noted earlier, as the court has held, and we think is correct, rights that are incorporated apply in the same way to the states as they do to the federal government. And the subsequent decisions, contrary to what the state of Indiana claims, have not undermined Austin. The court decided a couple cases that are important, Ursary and Bajikajian. In Ursary, the court is considering a double jeopardy claim. And they adopted—
Counselor, you have about 1 minute left. Do you want to just wrap up and give a little summary, please?
Sure. Ursary is a different test for a different provision of the Constitution. Bajikajian is inapplicable for a couple of different reasons, which I won't go into. Your Honor, I submit that the Constitution compels the court to follow the original meaning of the 14th Amendment, that there are no serious reliance interests at play for the slaughterhouse decisions, that the court can implement a historically, textually, and legally sound framework for protecting fundamental rights that does not endanger the past precedent and that does not endanger principles of stare decisis. The court should restore the Privileges and Immunities Clause to its proper place in our constitutional framework by overruling Slaughterhouse and Cruikshank and Bradwell, and by adopting a forward-looking framework that protects the rights of all citizens against government infringement, both state and federal. Thank you.
Counselor, thank you very much. With 5 seconds to spare. Wonderful. If petitioners can put your microphones on mute, please. And if the respondents in Oregon can please take your microphone off mute. Okay, very good. Team from Oswego, you have 15 minutes. You can begin whenever you're ready.
May it please the court, my name is Sydney Von Arx, and beside me is my co-counsel, Elena Lee. The question before us today is whether the 8th Amendment's excessive fines clause should be incorporated through the 14th Amendment's due process clause or its privileges or immunities clause. The facts of the case are as follows. Tyson Timms was arrested and convicted of a Class B felony dealing in heroin and a felony charge of conspiracy to commit theft. To transport the heroin, he drove his Land Rover, valued at $42,058.30 over 16,000 miles. He received a sentence of 6 years, paying $1,203 in fees. A civil trial in which the state seized Tim's Land Rover in an act of civil forfeiture leads us to the question of the incorporation of the excessive fines clause and of whether the forfeiture of Tim's vehicle was a violation of that clause. The Bill of Rights contains those rights most fundamental to the public. Although the Bill of Rights only applies to the state governments, not the federal government, upon its ratification, almost all of the rights contained within have now been incorporated using the due process clause of the—
Counselor, can I interrupt you? You might have misspoke. The Bill of Rights, you said, as originally drafted, only applied to the states?
No, the Bill of Rights— okay. Yeah, although the Bill of Rights only applied to the federal government—
There you go.
Yes, I apologize for that mistake.
That's okay. I assumed you had misspoke, but I wanted to make sure we're all on the same page.
Yes. The Bill of Rights only applied to the federal government and not the state governments upon its ratification. But almost all of the rights contained within have now been incorporated using the due process clause of the 14th Amendment. In the case before us, we contend that the 8th Amendment's excessive fines clause should join the list of incorporated rights, and that the method of incorporation should be the due process clause, not the privileges or immunities clause. While we acknowledge that the protection against excessive fines is a fundamental one, we do not believe that the seizure of Tyson Timms' Land Rover qualifies as an excessive fine due to the precedent regarding civil forfeiture and the fact that Timms used the vehicle extensively for committing 2 felonies. The court—
Okay, so, Counselor, if I can interrupt for a minute. So, we asked your friend on the other side a few minutes ago about the difference between incorporation through the due process clause versus the using the privileges or immunities clause. What problems do you find in your friend's argument concerning the privileges or immunities clause from the other side?
Well, Your Honor, I think first of all, the petitioner argues that there is not really going to be a substantial difference, but there is, because the privileges or immunities clause applies only to the citizens of the United States, whereas the due process of law clause applies to all people within the United States. Thus, it can apply to people who have not yet gained citizenship, and additionally, it applies the Bill of Rights to corporations, which count as people but not as citizens.
Why is that a problem? I mean, it might be a problem in the sense that you want non-citizens to get rights. But, as courts, we simply apply the Constitution we're given, right? We can't just say, you get a right, you get a right. We go Oprah them, right? Why is it necessarily a bad thing if the Constitution says citizens get rights and those people get rights? Well, why is that necessarily bad?
Well, thank you, Your Honor. That's a good point. But I think, first of all, we live in a republic where all people need rights. It is a fundamental part of the American culture to give all people rights. Second of all, I think that the petitioner is wrong. There would have to be a lot of relitigation. There would have to be many more suits that would have to decide all of these cases again. And finally, the Equal Protection Clause in the 14th Amendment says no state shall deny to any person within its jurisdiction the equal protection of the laws. And it has been held in various cases that the equal protection, in Feng Wei Ting versus US, that discrimination based on alien status is a case of strict scrutiny and would demand strict scrutiny. And thus, it would be against the 14th Amendment itself.
What case did you just read? I'm sorry, I didn't hear the case you said.
Feng Wei Ting versus US.
What king? I'm sorry, there was a little ding I heard.
Yang Ting?
Oh, you're going old school. Okay, got it.
This is US, 1890.
Yeah, okay, good.
Also in Bernal v. Fainter. A state that discriminates on the basis of alienage can be a state law that discriminates on the basis of alienage can be sustained only if it can withstand strict judicial scrutiny.
So that's a fair point. That I think we probably would have a shift, but why don't we just do like this? We say, okay, we'll leave in place all of our old due process cases, and going forward, we'll just use privileges or immunities. We don't have to revisit all stuff. We'll just leave those in place, but we should try to be more consistent with original meaning going forward. Why can't we do that two-tiered approach?
First of all, I think that it is inconsistent. The court has to rely on stare decisis, and there are previous opinions on this matter. And so to suddenly turn around like this and arbitrarily incorporate half of the amendments one way and half the other way is something that just is inconsistent. Second, I think there's still the issue of unincorporated amendments. And if we use the privileges or immunities clause, we are going to have to deal with the excessive fines, with the 7th Amendment and part of the 5th Amendment, which have not yet been incorporated. So we're going to have to start using grand juries and have to start litigating anything over, what is it, $30? $20.
Good. Yeah. Well, the court actually recently granted a case for next term about whether the requirement for unanimous juries is a privilege or immunity citizenship or right of due process. So I think you're right. There are other cases. But let's talk a little bit about stare decisis as well. Your friend on the other side gave us things to think about. How would you describe stare decisis, and when should the court decide maybe not to stand by its old precedents?
Stare decisis ensures that the courts have consistent opinions and that the law is applied in a consistent and therefore just manner. And so I think that stare decisis is a good general rule so that everyone can have the same court. But I think that it is important to consider in this case because there is so much precedent for incorporating via the due process of law clause. I do think there are cases where if the law has really been interpreted or if the Constitution has been interpreted in a slightly wrong, outdated, or unjust way, then yes, it is reasonable if there is substantial reason to interpret it differently.
Okay. So can you talk a little about the ratification history of the 14th Amendment? Your friend on the other side gave us some evidence. I mean, is there an argument to be made that those who drafted and ratified the 14th Amendment thought the due process clause would be the basis for extending rights to the states? Is there any evidence to support that?
I think that fundamentally the drafting of the 14th Amendment was intended to give freedmen the same rights as other people in the United States. The 14th Amendment, first of all, was meant to remedy sort of the injustice of Dred Scott. And Dred Scott really argued that because enslaved people were not citizens, they could not have the rights. So I think it would be almost ridiculous to say that the Privileges or Immunities Clause, which specifically says these rights only apply to citizens, is supposed to remedy that issue, whereas the Due Process of Law Clause applies to all people, and thus.
So, Counselor, but let's just talk about Julie. I'll let you the same question.
Yeah, we might be asking the same question.
I think we are.
That the 14th Amendment is ratified after the 13th Amendment, right? Which abolishes slavery and therefore would recognize the full citizenship rights of freed people, correct?
Correct.
So in this post-14th Amendment climate, we're really not necessarily talking about non-citizens.
I acknowledge that you are discussing citizens in this case, but I think the general intention of the amendment is to make sure that all people have certain fundamental liberties guaranteed in the Bill of Rights. Additionally, I think that the ratification of the 14th Amendment is based heavily on language in the 5th Amendment, and the Due Process Clause says that, the Due Process Clause in the 5th Amendment says, nor be deprived of life, liberty, or property without due process of law. And both of those are based on Magna Carta, which proclaims, no man of what state or condition he be shall be put out of his land or tenants, nor taken, nor disinherited, nor put to death, without he be brought to answer by due process of law. And I think both of these are more fundamental legislation, and they are used to ensure that all people receive just application of the laws, and that the laws are not applied unfairly, especially both mention taking property, and that is what we are looking at. We are not looking at whether or not a specific law is unconstitutional, but whether or not an application of the civil forfeiture law, this particular case of civil forfeiture, is excessive. The case is not about whether or not civil forfeiture in general is always excessive. It's about this particular excessive fine. And excessive fine.
Counselor, can I just intervene, right? So the clause says you shall not be deprived of life, liberty, or property without due process of law. Wasn't Mr. Timms given a trial before and a hearing before his property was forfeited? Wasn't he given all the process he was due?
That is why we held that Mr. Timms should not have, or the state of Indiana should be able to take Mr. Timms' land over. We are the.
No, I get that. But if he's given a hearing, then there's no liberty interest that's being violated. In other words, why do you need to say that this is a liberty interest the states must regard if you can simply say that they have to give him the process of law before taking away his property? In other words, they wanted to take his property, right? Deprive him of his property.
Yes.
They gave him a hearing. Why do you even need to have incorporation at all? Why can't this just be a deprivation of property?
So their definition of civil forfeiture of an excessive fine is a fine so grossly excessive as to amount to a deprivation of property without due process of law. That's from Waters Pierce Oil Company v. Texas.
Yeah, but you said due process. That means process, like a hearing or a trial. What I think you're saying is it's not fair because the fine's too high. How do you go from saying that the fine is too high from language that talks about fair process?
It's a fine that is excessive, and
I get that.
Is defined as to amount to a deprivation of property without due process of law.
I get that. No, I know that. You're reading it. Yeah.
Justice Blackman, let me frame the question a slightly different way. Okay, Counselor, can you actually take us through the due process analysis in this case so that we should consider whether or not we should apply the excessive fines clause via the due process clause given our current jurisprudence?
We believe that the case at hand is asking whether or not Tyson Timms was given an excessive fine and whether or not that can be applied to the states. And so the issue of whether or not the fine was excessive is simply asking whether or not due process of law was followed.
Counselor, I'm gonna interrupt you one more time because I'm not asking about whether or not the fine was excessive. I'm asking about whether or not we ought to be applying the excessive fines clause to the states through our due process jurisprudence. Can you take me through that analysis?
Yes, there are several reasons why it should be applied through due process. First, the right to not have excessive fines is listed in the 8th Amendment, and the 8th Amendment has always been incorporated, just like every other amendment, via the due process of law clause. The 8th Amendment says that you cannot have excessive bail nor be deprived, Constitution. The 8th Amendment says that no citizen shall be crime.
And you have about a minute left, Counselor, but you're always welcome to read from the Constitution in our tournament. That's always a plus. You're never penalized.
So that's 18. 5. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. And it speaks excessive bail and cruel and unusual punishments in the same breath and pattern as excessive fines. These parallel clauses are parallel issues of the government not following an appropriate process in punitive measures. The only difference is whether the punishment is bail, something unusual, or fine. Naturally, they should be analyzed in a parallel manner. That is why the court went so far as to presume the excessive fines clause was already incorporated under the due process clause in Cooper Industries versus Leatherman Tool Group Inc. Moreover, the language about depriving a citizen of life, liberty, or property clearly permits the court to apply the 8th Amendment to civil forfeitures, as civil forfeitures are easily classified as deprivation of property, but may not always be considered a fine.
Wow, perfect timing. There's my alarm. Wonderful. Okay, thank you so much. Could the team from Oregon please put your computer on mute? And we will go back to the team from Minnesota. And you have 5 minutes for your rebuttal, and you may begin whenever you're ready.
Your Honor, may it please the court. Respondents raised several arguments as to why the excessive fines clause should be incorporated through the due process clause. They are all unavailing. Respondents argue that stare decisis concerns require the court to retain slaughterhouse. Firstly, there are virtually non-existent reliance interests at play. The court traditionally upholds decisions when lay people base their decisions on precedent, or when decisions concern fundamental questions of government power that legislators rely on. As the court acknowledged recently in Janus and Wayfair, the grievously erroneous nature of a decision is itself a sufficient reason for overruling. Secondly, the slaughterhouse decision has gravely injured the rule of law by forcing the court to expand the due process and equal protection clauses beyond their proper scope. This expansion leads judges to question correct applications of due process, and citizens to question the wisdom of a court that relies on incorrect doctrine. Even Lawrence Tribe, someone with no small conception of stare decisis, has no problem with overruling slaughterhouse. The court should not let the mere fact that a precedent is long-standing stand in the way of historical consensus. The state of Indiana also contends that because non-citizens may not be covered by privileges or immunities, the court should continue incorporating through due process. This may very well be a question for a different time, as the petitioner is a citizen, and under any interpretation of the clause, his rights would be protected. However, even if the clause does not protect non-citizens, there are many reasons why this should not deter the court from using privileges or immunities clause. Respondents forget the existence of 50 other state constitutions that guarantee individual rights. State constitutions universally do not distinguish between rights granted to citizens and rights granted to non-citizens. Additionally, the 9th Amendment, which...
So Scott, if I can just interrupt you for a minute, I think your friends on the other side raised a fair point. Under the court's due process jurisprudence, incorporated rights apply the same to citizens and non-citizens alike. Were we to go down the road of your proposal, the government could not deprive a citizen of his assets, but they could seize the assets of a non-citizen, maybe someone here on a green card, right? A permanent lawful resident, a lawful permanent resident, or someone on a student visa, maybe, right? How do you respond to the argument that your approach with privileges or immunities would not give the same level of protections to non-citizens, even those here with permission lawfully?
Well, it's about looking at the rights that are, first of all, historically rooted in our nation's tradition, and about going about using the approach that is the most textually accurate to protect those specific rights, those that are historically rooted. As for other rights that need to be not distinguished between citizens and non-citizens, there are other avenues to protect non-citizens. But when you look at the actual—
What are those avenues?
Yep, that was my question. Yep.
Yeah.
What are those avenues?
Other state constitutions. Additionally, the 9th Amendment, which refers to the rights retained by the people, includes some of the same rights as the Privileges or Immunities Clause. So there are other avenues to do such.
Would we have to go back and knock out any protections we've given to non-citizens in the past?
Well, this is a forward-looking framework, so we're not looking to go back and try to essentially overrule past decisions about the protections and distinctions between protections of citizens and non-citizens. This is a forward-moving framework. We are looking specifically at protecting certain fundamental historically rooted rights within the first eighth.
Well, Counselor, let me interrupt you, and I want to be fairly brief because I know you only have 5 minutes, which is, while you may be forward-looking, there are undoubtedly potential litigants all over the country watching this, and they may decide, and perhaps are likely to decide that they'd like to bring cases that would cause us to reconsider the settled cases that we've decided under the Substantive Due Process Clause. What then? What do we do then?
Well, as my co-counsel stated earlier, some of the rights that are protected under the Substantive Due Process Clause in the past would be virtually similar or the same as some of the rights protected by Privileges or Immunities Clause. But it's about looking at the fact that the Privileges or Immunities Clause is a more appropriate and textually accurate vehicle moving forward. So we're not looking to overturn previous decisions made with substantive due process.
Okay, you have about 40 seconds left if you want to summarize, Counselor.
Yes. So, respondents state that inland forfeitures do not constitute fines. This runs directly contrary to the court's prior rulings. In cases of Austin versus United States, the court ruled that if a forfeiture is punitive in any way, it is a fine. Additionally, the decision in United States versus Usury is one that uses a different standard concerning criminal forfeiture and focuses on the double jeopardy clause, which doesn't undermine the decision in Austin. The court should recognize the historical pedigree of privileges or immunities, understanding the benefit of its incorporation as a textually accurate approach. Through this, excessive fines must be incorporated.
Very good. With 6 seconds to go. Very good. Thank you, Counselor. All right. If you could, in Minnesota, please put your microphone on mute, and we'll switch to the team in Oregon. And please take your microphone off mute. And we begin whenever you're ready. You have 5 minutes for rebuttal.
Your Honor, we do not believe that the petitioner's argument based on incorporation using privileges or immunities are valid in this case. First of all, the petitioner argues that due process incorporation is inconsistent with the original meaning of the 14th Amendment. Just because the office of the 14th Amendment desired to protect freedom against discrimination by the state does not mean that the privileges or immunities clause should necessarily incorporate the Bill of Rights. For example, in Paul v. Virginia, the court defines the privileges or immunities of the comity clause to be upon which the privileges or immunities clause for states to be dependent on a particular state's constitutional laws. The comity clause thus does not protect specific privileges and immunities, but rather grants the ones that one state chooses to grant to all citizens, all states. And as the petitioners argued, that the intent of the 14th Amendment was to give freedom their rights and to protect against discrimination. But
so Counselor, if I could just interrupt you briefly, please. You know, your friends on the other side, they gave statements from Senator Jacob Howard and others, which seem to suggest that the first 8 amendments were privileges or immunities of citizenship. I mean, that record, we can argue about it, but I think that's pretty good evidence. How would you respond to their evidence that the debates of the framers, who they cited Corfield v. Coriel, they cited the first 8 amendments? What's your response to that argument?
Well, I believe, as we have previously argued, that we should go off of the court's long tradition of stare decisis and using due process instead of privileges.
No, I get stare decisis. Well, let's just talk for a minute just as an original matter, right? Forget the last 50 years ever happened. How do you respond to the originalist argument that we have pretty good evidence from the framers? They said it, that this means the first 8 amendments, including the excessive fines clause. What's your response to that argument of why we shouldn't give that weight?
Well, I think that the framers, the 14th Amendment was it was written after the framers of the Constitution wrote the Constitution, obviously, and so the framers of the Constitution could not have could not have a perception of what, they couldn't see into the future. They didn't know what rights would be required in the future. And I think there's also an inherent contradiction between what the petitioners argue for historical context and what they're talking about here, because if the Constitution is a forward-moving framework, then how can you also use a historical approach in this case? And there's also the fact of the Ninth Amendment that Madison included, so as not to limit the rights that are given to people within the United States. And if we adhere strictly to the rights that are interpreted to have a fundamental foundation in the United States history, then we ignore rights that might arise in other cases. And also, if we look at the fundamental nature of the rights themselves in historical context, then African Americans still would not have the right to vote, because in the history of the United States, in the very early history of the United States, African Americans did not have the right to vote. And also,
we had the 15th Amendment, didn't we?
And by the same token, we have the 14th Amendment, which applies these provisions in the Constitution that were not originally applied to the states.
By virtue of which clause, though? That dance around the questions, that due process or privileges or immunity. All right, you have about 45 seconds left. You can wrap up as you wish.
Okay, so we believe that the petitioner's claim is the combined influences of stare decisis, the interpretation of specified as a procedural right, which renders the concerns about substantive due process to be irrelevant anyway, and also the negative consequences of incorporation using privileges or immunity, which would potentially violate the Equal Protection Clause, and also could lead to incorporation of the unincorporated rights that could be problematic, such as trial by jury for civil cases. Instead, the court should use due process to incorporate the excessive fines clause.
Counsel, your time is up. Thank you so much. Okay, both teams, you did fantastic. We are very proud of you. These are not easy questions, and I think you both grappled with very tough issues of constitutional law and history on a very profound level. I'm proud of you. You did wonderful. We don't have any scores to announce today. We still have a bunch of other teams to grade, but know that you've done very well if you prepare yourself. Julie, would you like to help us sign off?
I just want to reiterate what Josh said, which is this is not easy to do. With any legal question, you're dealing with a fairly complex legal question, one that the court actively is dealing with. I think you both shepherded really good arguments for both sides. You should be incredibly proud of yourselves. We know how much preparation went into not only writing your briefs, which were great, but also for preparing for today. So you should be very proud of yourselves. We did not ask easy questions, which we never do. And you handled them about as well as anyone could handle these kinds of questions. So please be proud of yourselves. I know we are. And it just seems like every year, Josh, the students that participate get better and better. So we are so pleased that you participated. As Josh said, we have several more rounds to score before we release the finalists, who they will be. So that I think we'll probably have around April 8th would be my guess.
Yeah, wonderful. Okay, without any further comments, court is adjourned. Good luck, and we'll be in touch. Thank you so much.
Bye-bye.